It's time to ask the attorney. Gilbert Adams is here to answer your legal questions. Thank you so much for joining us.
Great to be here.
Let's get started. I lived with a man for 18 years in a house he bought, although we were not married. We split mortgage upgrades and had an agreement to divide equity 50-50 when the house sold. We no longer live together and he is reneging on the agreement. Can I force him to give me half of the equity?
Well, there's two problems here. First, the first problem is there's no writing. You don't have a written agreement with him to share the equity. A bigger problem is that title to the home is only in his name. Title to something is so important, whether it's a car or a home or whatever. You really ought to have your name on the title. So, but in this instance, I think given the history, there's an 18-year history.
Right.
I think there is something that she could do. She could file what we call an action for partition. If she has evidence of showing that she's done these things, I think he's going to have a hard time denying it. So it's not the best way to go about it. It could be expensive, but I think there's some relief for her.
But definitely good to note, have your name on anything.
Have your name on the title and have an agreement. Anytime you have regarding land, a house, there should be a written agreement. Anything affecting land. So next time, a written agreement on the deal, and then if it affects land, to have a writing too.
All right, sounds good. Second question, can a debt collector contact me about a debt that has been removed from my credit report?
There's two issues going on here. Usually, if the debt collection firms have a 7-year period of time that they keep things on your record. But the statute of limitations in Texas for a debt is 4 years. So yes, can they contact you? Yes, there's nothing preventing them from contacting you if you owe the money. Now, whether you have a valid defense to the claim to repay the debt, you very well may if it's been more than 4 years. So they can contact you, but you may have a good defense.
Wait, so what do you mean there's the 4-year statute of limitation in Texas?
Well, if there's 4 years has elapsed since there's been a breach of contract, then the suit is no good. There's nothing they could do to enforce a judgment on you, so you would win any type of a lawsuit.
Oh, okay. And last, can the court decide to remove my ex's parental rights due to him being disrespectful, degrading, and emotionally/verbally abusive towards me?
As you can imagine, courts, judges who handle these types of cases hear this in about 90% of the cases. The judge isn't really there to police the conduct between the parents. The judge is going to want to see everyone get along, but the answer, could you take away parental rights to a child on account of being disrespectful to the parent? That's not likely going to happen. There's only certain there's about 12 reasons a judge can do that, and this isn't one of them. The judge isn't going to like to hear this,
sure,
but taking away rights, that's not going to happen for that.
All right. Well, of course, if you have a question that you'd like to submit, you can email it at asktheattorney@fox4beaumont.com, or you can call Gilbert Adams yourself at 835-3000 with your legal questions.